Wonderful. Thank you, Amy. On behalf of the Milk Bank, I am just thrilled to welcome everyone to today's webinar, An Employer's Guide to Lactation Support. Our mission is to save infant lives and improve health outcomes by providing access to safe human milk. We can only achieve that thanks to the compassion and generosity of more than 1,000 new milk donors annually who donate to change the lives of families that they never get the chance to meet. In many of these cases, our milk donors are supported by amazing employers who deeply understand that what's good for babies is also good for business. We are excited to be part of supporting family-friendly employers, and you'll get the chance to request a free lactation room support kit at the end of this webinar. But before we get started, we are interested in learning how familiar you are with workplace lactation support, especially compliance issues like the Pump Act. So if you could pop your answer into that question into the chat, that will help us develop next strategies and some outcome goals. So just let us know, are you familiar? Not very familiar, just a little bit. As you're answering those questions in the chat, I wanted to talk a little bit about how this collaboration launched. Our very first partnership was to our funder and our philanthropic friends that made today possible, the Women's Fund of Central Indiana. I am so grateful for their vision and understanding of all the spaces women occupy, because women should never have to choose between their own health, their infant's health, and their employment. The next two calls were to our incredible expert speakers, who I have the thrill to introduce now. We will be dropping their full bios into the chat for you to review, but I want to share Shelly Jackson, partner at 𝘁𝗍𝗍, where she serves as the Labor and Employment Practice Chair, as well as an active community volunteer, including serving on the Milk Bank's Board of Director and our Advancement Chair, as well as Ashley O'Rourke, the Director of Community Employment Engagement with the Wellness Council of Indiana, where she leverages her rich public health background to create healthier places for us all to live, work, learn, and play. We couldn't be more grateful for their leadership and know you will leave today with practical tips for yourself, your workplace, and your communities. Ashley, take it away.
Absolutely. Give me a moment while I share my screen. All right, is everybody seeing my screen share? That's beautiful. All right, so good morning, everyone, and thank you for joining us today. I'm so excited to be a part of today's conversation, along with Shelly Jackson, as we really dive into strategies to support lactation accommodations in the workspace. By the end of today's session, you'll have actionable insights into creating a lactation-friendly work environment. All right, I do have my professional bio listed here. And thank you for Freedom for giving me a little summary. However, shameless plug, that is a picture of my son here. And I thought I could kick off today's conversation with me sharing my employee testimonial to really show the impact of solutions and how they can increase the culture in your workspace. So as a new mother returning to work full-time, I was really struggling and challenged by missing my son and the physical toll it was taking on my body, and specifically my milk supply dropping. I often question if I was making the right choice by working full-time, especially when trying to balance my responsibilities as a new mom and employee. But I'm fortunate to work for an organization that didn't just offer me accommodations. They took the time to ask me what would be most beneficial as I navigated this new chapter. So together, we developed a solution that worked for me. In this situation, it was a flexible hybrid schedule that allowed me to nurse my son during my breaks when I was at home with its primary caregiver. And then on my days in office, I was able to have that caregiver bring my son in during my lunch hour so I could get that contact time and really get my milk supply back up. So this flexibility, though, it was really a short-term accommodation. It really impacted me allowed me to stay in the workspace. And then honestly create a sense of loyalty that's going to go far beyond my childbearing years as I remain committed to my workspace. All right. I think is my camera off? They're still seeing it. Okay. So I am with the Wellness Council of Indiana. I'll keep this very brief, but we are a 501c non-for-profit organization and a subsidiary to the Indiana Chamber of Commerce. It's through this partnership that we have a workforce and economic development approach to employee health and well-being. We are a member-based organization. Members receive recognition, best practice sharing, employer solutions, and opportunities to convene with other wellness professionals from throughout the state. All right. As we dive into today's conversation, I would like to begin with a level set. So women make up a large portion of the workforce, yet many face unique challenges related to pregnancy, childbirth, and nursing. So supporting mothers through these phases is not just beneficial to them, but also to your organization. So let's explore some of these statistics around maternal health, infant mortality, and underscore why lactation support is so important in the workspace. All right, according to the U.S. Department of Labor, 56.2% of women work outside of the home. So we're making up a large majority of the workforce. And since 2015, the number of women in C-suite positions have increased from 17 to 28%. And the representation of VP and senior vice president levels has also improved significantly. So we're holding significant roles in the workspace. And our numbers, as you see here, are continuing to grow. We see a small decline in 2020 during the pandemic, but we are back up and growing furthermore. Additionally, more and more mothers are working and returning to work. So we as employers need to understand that the population has a unique set of needs, support, and potential accommodations to have the best health and retainment outcomes. All right, as you can see from this list, Indiana ranks among the highest states for infant mortality. This highlights the urgent need for improved maternal and infant health outcomes, including ensuring that new mothers have the support they need to breastfeed and express milk. Employers play a significant role in improving these outcomes by offering lactation-friendly policies. All right, and that being said, now let's dive into why breastfeeding support isn't just good for mothers, but also good for business. Breastfeeding has a positive impact on both the health of mothers and their babies, which ultimately benefits your bottom line. Research shows that companies that support breastfeeding employees see lower healthcare costs, reduced absenteeism, and higher employee productivity and retention. Breastfeeding leads to healthier babies and moms. The benefits include stronger immune systems, reduced risk of chronic diseases, and better long-term health outcomes for both mother and child. For businesses, this translates to fewer sick days and a healthier, more engaged workforce. Research shows a return on investment for companies supporting breastfeeding as a 3-to-1. So 3-to-1 is huge in this space. And we see in this chart here that mothers with breastfed infants have experienced significantly less absenteeism than formula-fed babies. We see here the 25 versus 75%. And here, retention rates for companies with lactation support programs is significantly higher than the national average. So we see the 59 versus the 94.2%. Despite these benefits, many employees face significant barriers in breastfeeding in the workspace. From inflexible hours to lack of privacy, these obstacles can lead to frustration, lower productivity, and higher turnover. It's essential that companies recognize and address these barriers to create a supportive work environment. All right, and as we move forward, it's important to understand that accommodating nursing mothers is not just best practice, it is the law. There are legal requirements in place to ensure that breastfeeding employees have the time and space they need to express milk at work. So now I would love to introduce Shelly Jackson, partner 𝘂𝗍𝗍𝗍, to discuss these regulations in more detail. Stop sharing. Here you go, Shelly.
Thank you so much, Ashley. I'm so glad to be here today with the Milk Bank, and particularly Ashley, who I've had the joy of collaborating with Ashley for several years now. We've worked on different initiatives about wellness in the community and creating great spaces for employees with a variety of different needs and requirements. And so it's a pleasure to present with her as a co-presenter, and then also be part of one of my passion projects out in the community, which is the Milk Bank. I've had the joy, excuse me, to be involved with for several years now, also through the Milk Bank as a board member. And it's one of the most rewarding opportunities that I get to be in the community. So I really appreciate the invitation to join today. Let me start by getting my PowerPoint going here for you. So everyone hopefully will see my presentation. And as Frida mentioned, in her introduction, I am an attorney who practices in a number of different areas, but the two areas that intersect most perfectly with this topic are employment law, and then also I'm a healthcare lawyer. So this is a very interesting topic for me. We've been doing quite a bit of work in the space of assisting employers in envisioning new ways to accommodate employees within the workplace. I do want to caution you before I jump into my part of the presentation that while I am a lawyer, I'm not, to my knowledge, your lawyer. So be careful about understanding that this is general advice. And this is really a survey and an overview. I absolutely love how many of you in the chat screen have quite a bit of familiarity with some of the workplace standards for breastfeeding in the workplace. So I think that's a great way to get started here. And I look forward to engaging in conversation. I know we have some time for a little bit of follow-up questions afterwards, but let's dive right in. So we're going to do what I would call a tour of a couple of main laws that provide the federal framework for accommodating employees in the workplace. That doesn't mean they're the only laws that provide a framework for accommodating employees in the workplace when it comes to pregnancy and lactation, but they are primary laws, and they are also relatively new laws. So we will do a whirlwind tour. So the first one is what is called the Pregnant Workers Fairness Act, and it is a federal law. It went into effect in 2023, and it really sought to close a gap as it related to pregnant employees and pregnancy and related conditions within the workplace. Prior to passing that law, the requirement for an employee to be entitled to an accommodation within the workplace sat with the Americans with Disabilities Act. And again, that protection remains in place. It did not take away any protections that existed within what we call the ADA. It simply expanded the protections to include conditions of pregnancy. Sometimes, and what I mean by previously, ADA was the only federal law that required it, is that sometimes a pregnant woman may have a condition of pregnancy, but it may not rise to the level of a disability that requires accommodation under ADA. So the Pregnant Worker Fairness Act steps into that gap and creates an accommodation obligation that arises solely from conditions of pregnancy without separately establishing that there is a disability. So going through this, you're looking at the basics here of the law. You typically, as an employer, would need 15 employees. It covers both private and public sector employees. It does include what we call a reasonable accommodation obligation. We'll get into that in just a little bit. And it also, one thing that is different from the Americans with Disabilities Act is that the ADA requires accommodation for qualified individuals with a disability who can perform the essential functions of the job with or without accommodation. The Pregnant Worker Fairness Act goes one step further and says that it even covers people who have a known temporary limitation or even an inability to perform essential job functions. So it is not something where there is an accommodation that will allow someone, for example, to perform their job functions. In some circumstances, it will cover individuals who temporarily cannot perform the essential functions of their job, even with an accommodation. And it is based on a condition related to pregnancy, childbirth, and related medical conditions. And there is still the same protection that existed previously, which is that there is an undue hardship standard. Like the ADA, the undue hardship standard is a fairly significant standard to meet. So it's not an easy inquiry, and it definitely warrants some additional investigation. And two additional items, it requires an interactive process, which means a discussion that has to occur between the individual seeking accommodation and the employer. That is an obligation that sits on both sides. It is an obligation of the employer and of the employee. And it also prohibits both retaliation, in other words, retaliating against someone for attempting to access a desired accommodation. It also prevents coercion, trying to essentially bribe someone not to utilize a particular accommodation. And the other thing I will say, you'll see at the bottom of my slides, I have several hyperlinks, and I'm hoping we can circulate our content following this, or you're welcome to reach out to me. My contact information was in the original bio, and I'm happy to share a copy of it. And here's why. The Department of Labor and the Equal Employment Opportunity Commission have some fantastic resources that can help guide you through different questions that you have. So it's like a one-stop shop of just very limited, targeted, but very helpful resources that can help employers get a good glimpse at some of these requirements. But there is also what we call a final rule. So when there is a new federal statute passed, the agency that's responsible for implementing that statute promulgates rules. That means that they create rules that essentially guide the government and organizations in implementing the rule. Some things to keep in mind with respect to PWFA. First of all, employers should never assume a limitation exists or what the limitation is. That is something that we do see some friction with in the workplace. And here's why. Sometimes someone will see someone who is visibly pregnant or appears to be visibly pregnant and may assume that that person is requesting an accommodation. It really is an accommodation that is to be provided upon request. There shouldn't be an assumption, for example, that someone is not able to perform their job just because that person may or may not be pregnant. The second, again, that second bullet point is what I was just mentioning, that you should never make an assumption as to what is needed or what type of accommodation is needed. That's the interactive process. Talk about it, talk through it, and figure out what is the best accommodation in this scenario. And then also don't make changes that are not requested, because this really is an empowering statute versus a prescriptive statute. It's not saying that an individual who is pregnant in the workplace is not allowed to do X, Y, or Z. It is simply a chance for that person, if they require accommodation, to request and receive it. One of the things that has come up, you'll see this in a little bit. I'm going to try to speed myself up to get to the current litigation that we see going on in this space. But one of the things that is a key issue is trying to require an employee to take leave when there is some other common accommodation that could occur, and that accommodation is reasonable. This is actually fairly common also in ADA situations and sometimes Family Medical Leave Act situations, where there can be an assumption that, well, this accommodation feels more complicated than I had hoped, or it's easier to put someone on leave. There has to be an interactive process, and it can't be, the answer can't be to say it's just easier to put someone on leave, even if there is some other reasonable accommodation available. And again, if there are equally effective reasonable accommodations that don't cause undue hardship, that's an obligation, that's part of that interactive process. So think about, as an employer, when you're thinking about accommodating employees in the workplace, there are some things to really kind of dig into here. And one of the things I really, really liked about Ashley's opening slides is that it highlights the importance, not just of basic compliance with the law, which is, of course, the standard that every employer should aim for, but the importance of thinking holistically about your workforce and understanding your basic compliance requirements, but really looking at it more from how do we create an environment where our employee can thrive? Because we all know that talented employees are in the workplace, they are experiencing pregnancy, childbirth, all of the things that go with that, and lactation, which is the second part of my comments today. And this is really a chance to support those employees beyond just the basic requirements of the law. There are also some other things to keep in mind. There can be other obligations, whether that's state or local laws that may have additional restrictions or requirements, or if there's contractual obligations, either an employment contract or a collective bargaining agreement that may apply. So what does it mean to talk about conditions, physical or mental conditions related to pregnancy, childbirth, or related conditions? Related medical conditions is an important definition. It includes conditions that are episodic in nature and related to pregnancy or childbirth. It can include things like postpartum depression. It could include things like preeclampsia. So all of those conditions that you associate with pregnancy and that are related to pregnancy would be included within here. High blood pressure, anxiety, carpal tunnel syndrome. It also includes, and this is something really important to keep in mind, look at the description of in the final rule that said of what's included. current pregnancy, past pregnancy, potential pregnancy, lactation, including breastfeeding and pumping, use of birth control, menstruation, infertility and fertility treatments, endometriosis, miscarriage, stillbirth, or having or choosing not to have an abortion. So it's a really broad range of protection that's provided. And not surprisingly, some elements of that protection have been subject to challenge, which we'll get to in a little bit, but it is a very broad statute. Some examples of accommodations, and I won't read through all of them, but these are good examples of things that you can change within the workplace to allow the employee to engage fully within the workplace, but continue to remain present in the workplace and working. Some other examples, and all of these examples, by the way, are not my own examples, they're in the final rule. So this is the Equal Employment Opportunity Commission through the Department of Labor that's sitting here and saying, here are things that we have identified as potential accommodations. Another area where we have seen some litigation is the idea of requesting what's called reasonable documentation. If, for example, an individual is pregnant and requests to sit on a chair for part of the day just because their feet hurt, you may not need medical documentation to document the need there. It's obvious that the person, they've announced or they've provided information to you that they are pregnant, they've told you they're pregnant and that they would like to have some time off of their feet. Now, if it's something more complicated, for example, they're having some sort of a related health condition that wouldn't be obvious, and that they are needing some additional accommodations that wouldn't necessarily be evident to an employer without medical documentation, it's always okay to request documentation in those circumstances. But it's only for the extent possible to determine whether there's a limitation or if they need a change or an adjustment at work relating to the limitation. It's not appropriate to request documentation that goes any further than that. And those are the guidelines. And again, there has been some litigation in this space. Here's like a big 5 of potential challenges that you can experience in the workplace, that employers can have in the workplace that are violative of the PWFA. If there's no accommodation provided or an unnecessary delay, I will say under the PWFA, delaying in providing an accommodation is essentially treated as a denial. So if you say, oh, wait a second, I'm not sure, we've got to think about it, we got to look at our policies, we got to figure it out. If you do that too long, it's deemed a denial. So think very carefully about timelines when you're responding to requests for accommodation. Unilaterally requiring an accommodation without engaging in the interactive process, refusing to hire someone. Anyone who has ever been pregnant when searching for a job or visibly pregnant when searching for a job knows that this is a thing. This is something that people worry about in terms of being denied employment opportunities because an employer is aware that the person is expecting. And so because of that, there's protections here. Now, there were already protections sitting in Title VII of federal law. So this is not new protection, it's just enhanced protection. And requiring an employee to take leave when a lesser accommodation is appropriate. Already talked about that. And then if there's any level of retaliation, and I should have added in there coercion, either trying to essentially convince them not to request an accommodation, including providing extra money or kind of bartering back and forth, and then retaliation, open retaliation, taking an adverse action against them. For any of you who are familiar with employment-related discrimination claims or accommodation claims under ADA or any of the other major federal statutes, it's a very similar framework. In fact, it really just borrows the framework that already exists. There is an administrative filing requirement. So that means that if I believe that I have been improperly treated under the Pregnant Worker Fairness Act, I can't just go into a court and file a lawsuit. There is an administrative process, what's called a charge. It has to be filed with the Equal Employment Opportunity Commission within either 180 or 300 days of the event at issue. In Indiana, it's 300 days because there is a partnership with Indiana state agencies. And so it does give us that extended 300 days for someone to file a charge. So we always keep that in mind. But back pay and front pay, compensatory damages, it can include emotional distress damages if properly documented. And then what's called punitive damages. Punitive damages are damages that are punitive. They're designed to punish. So you can have the actual damages that were lost, for example, money I would have made if I had not been treated in a manner that was unlawful, but then also punitive damages, the damages that can be done to punish an organization and keep them from doing it in the future, and then attorney fees and court costs. I'm going to spend just a few minutes here chatting about some litigation that we're seeing in this space as it relates to the Pregnant Worker Fairness Act. Then we're going to transition over to the PUMP Act, which relates specifically to breastfeeding and lactation in the workplace. There have actually been several federal district court lawsuits filed in an attempt to block implementation of the final rule on the Pregnant Worker Fairness Act. To date, there has been no nationwide injunction. And what that means is that the rule, when it went into effect earlier in 2024, it remains the law of the regulatory law of the land in most states. There have been some limited injunctions granted in a couple of states, not Indiana. And there are currently 3 different lawsuits that remain pending or have the potential to remain pending. They're pending or they've been dismissed without prejudice. Those lawsuits, I do want to make a comment here because of the 3 lawsuits, all 3 of them primarily challenge what is seen as abortion-related protection that exists within PWFA. However, 2 of the lawsuits, specifically the lawsuits that were brought by the states, not the religious organizations, actually seek to invalidate the entire final rule. They are saying essentially that the rule is based on improper authority. The EEOC never had the authority to issue this rule, and because of that, the whole thing should be thrown out. Again, there has not been any definitive ruling there, but they do remain pending. And then we also got to see in September, and this is very interesting for anyone who does follow these types of litigation, in September 2024, the EEOC came out swinging. They announced their first public conciliation, which means that it was like a settlement process with an employer who was accused of violating the Pregnant Worker Fairness Act. You can see there, $47,480 in damages, several other requirements, and public shaming, essentially. And then in September 2024, we also saw 3 more lawsuits. I won't spend a ton of time on them, but they really are kind of regardless of the merits of the lawsuits, and they have not been decided, they are continuing to pend, and it will take a very long time, a couple of years, maybe longer to get these completely sorted out. But if you look at the allegations, refusing to excuse absences, accumulating unauthorized absences, taking adverse action against employees. In this case, the employee resigned and filed a charge of discrimination. They're very similar types of allegations. And you'll see they're kind of a variety of different types of employers. This employer allegedly would not guarantee breaks to express breast milk upon the employee's return. One of these, and I want to see, here it is. Okay, this one here, which is by the way in Kentucky, which is one of the areas that that the milk bank serves. So it is in our backyard here. The employee was looking to transfer to a role that didn't require lying on her stomach, and that was denied, even though the employer allegedly had accommodated that request for other employees. So that's always something important to think about as well. For non-pregnant employees, if someone that needs to not lay on their stomach, is there an accommodation available? And the thing I wanted to highlight with this case, if you see, the lawsuit is not just the Pregnant Workers Fairness Act. It's the Pregnant Workers Fairness Act, Title VII, which provides protection against sex-related discrimination. And by sex, I mean discrimination against women on the basis of their sex, and the Americans with Disabilities Act. So this litigation is not just this one issue. It tends to be broader. It tends to implicate multiple different laws at the same time. And then this is a quote from EEOC Chair Burrows that just talks about their strategic enforcement priorities here, and that the Pregnant Worker Fairness Act is a priority for them, and they are engaging in enforcement activities. If any of you have ever seen me speak before, I tend to say that the EEOC doesn't file a lot of lawsuits, and that is a true statement. But this is what we're seeing. When there's a targeted enforcement strategy, we do start to see very specific action from the administrative side of things in lawsuits. So typically, so the way a charge is determined, so if someone files a charge of discrimination, the EEOC will investigate and decide whether they believe good cause exists to decide as to whether or not discrimination happened. Regardless of what that finding is, one of two things will typically happen, not regardless, but at some point, they will either engage in what's called the conciliation process in an attempt to resolve the matter, or they will issue what's called a right to sue letter, which allows the person to file their own lawsuit. And in this case, the fact that the EEOC is actually pursuing a lawsuit on the behalf of claimants, that's unusual. It typically does not happen. And because of that, that tells you that, or it signals, and they're saying it, that it's an enforcement priority. So even if kind of the best practices isn't compelling from the idea of just, wanting to have compliance and wanting to serve employees in the workplace and create spaces where they can thrive, there is an enforcement environment now. Question that I get sometimes is, with the upcoming transition in administrations, presidential administrations, does that mean that all of this goes away? And the answer is no. So the EEOC is a commission, and there are commissioners that are elected for specific terms. Now they can be removed, but it's not they do not serve at the pleasure of the president. They are nominated and they go through a process to be appointed, but there is some sort of a process that would have to be engaged. Now, it's possible that we will see a very quick shift in approach here, but it's not as easy as on day one. I don't think, I guess it could be attempted, but to say, okay, we're done, we're shifting gears. But I do have to say, I think it's probably pretty likely that we will see a shift, a dramatic shift, frankly, in some of the employment-related litigation as we move forward. All right, so I'm ready to jump in now to the second federal law that I think is a great framework for our discussion today, and it's the PUMP Act. It's kind of the star of the show, right? We're talking about lactation in the workplace. This is an act and it stands for Providing Urgent Maternal Protections in the workplace, because Congress always loves a great acronym. So there you go. It actually went into effect in 2022, or excuse me, it was passed in 2022, went into effect in early 2023, April 2023. And this is the kicker. This is a broadly expansive number of employers that are covered. If you are an employer that is subject to the Fair Labor Standards Act, almost certain that you are going to be affected in some way by the PUMP Act. There is a small employer exception for employers under 50 employees. I do, however, want to note that previously there was a small employer exemption that was pretty like you could just say, I'm a small employer, and you were not covered by it. Now the exemption requires an analysis to determine whether an undue hardship exists, and it really sets some fairly stringent standards to meet. So even if you're a tiny employer, I would urge caution in assuming that it doesn't apply to you unless you've gone through that analysis. And it covers all employees, excuse me, of a covered employer for up to 1 year following the birth of the child at issue. Nearly all employees who are covered by the Fair Labor Standards Act. Another big change, it includes both exempt and non-exempt workers. So under the prior federal standard, non-exempt workers were covered, but exempt workers were not. And now this includes everyone. And then it also includes some workers there are sometimes some exemption standards for overtime requirements. It's not like what we think of as like an administrative or white collar exemption. There are some other exemptions. Taxi drivers, for example, fall within that. It also covers individuals falling within that area. It does have some exemptions. So the exemption for crew members of air carriers, and then for train crew members, and this tells you the breadth of this coverage, because even in the exemptions, they're not really full exemptions in some cases. They're just delays, saying that we're going to delay a little bit in implementing it. But this one is motor coach and locomotive workers. Key features: has to be shielded from view, free from intrusion, not a bathroom, functional for expressing breast milk, and available whenever a nursing employee needs to pump. Pretty straightforward. And frankly, sometimes it takes some creativity, but should be fairly accessible to set up. there is an ability for an employer who can't set up their own appropriate workspace to partner with a third party to provide the reasonable workspace availability. An example, taxi driver can partner with places along the taxi route for the individual to pump if there's not another suitable space. And then also keep in mind that while there is quite a bit of flexibility in implementing spaces, think very proactively about meeting the compliance requirements. So for example, if there's a tractor trailer, you know how sometimes the tractor trailer have the sleeping spaces in them, that may or may not be a functional location or space. You have to evaluate it. What is it? Does it fit the adequacy requirements for the breastfeeding space, or even a pop-up tent? It doesn't have to be a permanent structure. You can utilize alternative structures, but you have to make sure that it does meet the standards. And some will and some will not. So it's really important to look into that a little bit more. And then this question, I have to thank Ashley because this question came up and I thought it was an interesting one. So the question is, you have to provide an electrical outlet? And the answer is ideally, yes. But the word ideally is important here because the statute itself doesn't actually provide that there has to be an electrical outlet. It doesn't set like electrical standards or anything like that, but it does say that it has to be a functional space. And so ideally that includes both an electrical outlet and a sink. And so there are some areas that I would say are recommended from a compliance standpoint. Will you be dinged or will you be out of compliance if they're not there? I think it depends on the circumstances. This particular regulation does sit underneath and arises from the Fair Labor Standards Act, which sets our minimum wage and overtime standards. So it's essentially a wage protection statute is what it is in its general sense. It provides some additional protections. There are some instances, depending on the type of non-compliance, where an employer does actually have a right to cure, which means you tell them that there is a non-compliance and they have 10 days to fix it. That's not true in all situations. For example, if an employer is willfully refusing to implement an accommodation, that 10-day period would not apply. The other thing is that retaliation is prohibited, as there was on the other law. And I want to spend just a little bit of time commenting on the violations and the remedies that are available. These are significant. These are not like small potatoes. And here's why, because it can be a fine of up to $10,000 per violation. Let's think about that from the status of a worker who has been seeking accommodation under this act or their rights under this act. Every single time they are denied the right to pump at work can be considered a separate violation. So you think about this, you can add this up. And if you have 50 workers who, well, maybe I'm sure they wouldn't all be pregnant at the same time unless you had a very large workforce, but or breastfeeding at the same time. But let's say you had 50 breastfeeding employees who were denied accommodation in that space and were entitled to it, it's $10,000 per violation. So it can add up very quickly. And then there are other more conventional remedies, employment, reinstatement, promotion. I didn't even realize that until I started preparing and going back and reading back through the remedies that are available. But even the idea of promotion to a different job can be one of the remedies that is ordered. I have to say those types of remedies are much less common, but it is technically available. And it also creates separate remedies for retaliation. So if an employer is found to have retaliated, then there are actually separate remedies that come in and essentially layer on top of the other remedies that are provided. There are state laws that provide either companion or enhanced protections. I found a great nonprofit organization that tracks state by state the different lactation laws that apply. So I recorded a couple of them here for Indiana, Kentucky, and Missouri. One thing you'll see here in Indiana, for example, where I say reasonable accommodation, sort of, because the laws are not particularly stringent. So that particular statute, for example, it gives an employee a right to ask for accommodation, but it doesn't actually set a penalty if the accommodation is not provided. So it is kind of, that's why I say sort of, like, yes, you have a right to ask, but the employer has great discretion on whether they grant it. And there, we've seen a bunch of lawsuits here. In fact, you probably see them online or on the news sources. Tons of lawsuits are being filed, dozens of them. There's generally three types, and I'm at the very end of my comments, but I'll just kind of quickly run through these. The first one are individual lawsuits. For example, 𝗪𝗿 versus 𝘊𝗵𝗲 that was a person, last name 𝗪𝗿, who sued because of her particular scenario. Then there's something what we call collective actions, and that's the 𝘪𝗫 case against the U.S. Postal Service. And that's what a collective action means, that there are a group of employees that are represented in the litigation, and employees can opt in. So it's a group of employees, but the employees would choose to opt in to the litigation. And it can include former employees, applicants who were denied some sort of a benefit, things like that. And then the last one is 𝗕𝗿𝗄 versus McDonald's is an example of a class action. A class act, we all know class actions, right? That's where you get the little postcard that says, you get $3.52 and the lawyers get like tons of money. And if you don't object by X time, you're going to be bound by the settlement. That's a class action where there is, there may be injunctive relief sought where a court tells an organization to do something. There may be a financial reward because it is this particular statute is a wage statute. I think I am at the end of my presentation, but thank you very much. And I'm going to turn it back over to Ashley to really dig in on the key part here, the holistic part here, which is how do you make your workplace work really well for your employees? I'm going to unshare. Sorry, Ashley.
Yeah, no problem. Can you guys see my slides? Yes.
I can. Yes.
Beautiful. Okay. All right. So I'm going to take the next 10, 12 minutes or so to kind of just talk through some best practices. And I think that 𝘱elle really stated that well. But once again, going to highlight that compliance is not best practice. It's simply a starting point. So as we kind of go through some of these sections, I'm going to note the compliant pieces as well as the best practice suggestions as we view this as more of a retainment and attraction standpoint. Additionally, as I'll be going through these pretty quickly, I would like to also note that the Wellness Council of Indiana does offer consultations in the maternal health lactation space that are completely free through our funded Indiana Department of Health. So if you're interested in scheduling a consultation, we can have a 60, 90-minute conversation and really explore how we could support your unique space as you guys launch your lactation program. So, all right, in this section for today, we'll be exploring key strategies and best practices for supporting nursing mothers in the workspace. This includes creating the right environment with lactation rooms, implementing flexible scheduling, providing educational resource. We'll also cover the importance of formal policies, and I will be providing some templates of formal policies as well, maternal mental health, and then briefly touching on inclusive family forming benefits as well. All right, so providing a private lactation space is key in supporting nursing mothers in the workspace, while the basic room essentials, which 𝘱elle covered, such as a clean, private area, are the minimum requirements. It's also important to include those essential components. And I think the word essential, once again, as 𝘱elle said, is so important because the need is there. This could include a comfortable chair. I'm sure many of us have tried pumping or nursing on the floor. It is not ideal, and we need that comfortable chair and is essential. A flat surface for us to set all of our equipment on. You know, while we're pumping, there are a lot of pieces. There's all the bottles, the different hookup pieces, the cords, the actual pump itself. So consider having that table in the room as well. The electrical outlet I struggle with, I had to actually reach out to 𝘱elle about, because the majority of insurance covered pumps do require that electrical outlet to be like actually plugged in. There are cordless options out there, but through many insurance providers, there is an additional fee for that cordless option as well. So making sure that we are, closing that barrier and providing that access. Additionally, access to running water, being able to clean those pump parts as well when we're done, opposed to having to carry them out in our hands, to that break room is really a great essential component to the room as well. And then refrigeration for milk storage, and we'll discuss options in that space here in a little bit as well. Lastly, the word accessible, making these rooms accessible. I've had consultations with some really well-established programs like, well, we have this beautiful room. However, their facility is 3 separate buildings. There's one room in one building. So that individual may have to walk a significant distance to get to that lactation room. So making sure that if that is truly the case, that we're providing either a closer room or the appropriate break time to walk over to that space, and still have plenty of time to pump as well. So just things to consider as we're thinking about that location. Room options. So once again, there are many different room options in creating lactation rooms depending on the available space. You can repurpose private offices. And if you don't have that space, temporary sections or large conference rooms can be transformed. The key is to make sure that the space is private, clean, and equipped with necessary essentials. So if we have a conversation and a consultation, we can really dive through, inventorying your rooms, spaces that might be available or might be a potential opportunity as well. The larger rooms that are partitioned, though, just once again, shielded from view, using the term that 𝗪𝗟 shared, is very important in that space. And then furthermore, I'll be saying this throughout my presentation, talk to that nursing parent. Are you comfortable with this setup? Does this suffice? I know when my employer was setting up my office, there were a couple of different things that I needed. I have a window on the front of my office in the back. So making sure that there were blinds put up to support me in that space, so I felt comfortable nursing in my office as well. And then just asking if there's anything else that I needed to be comfortable in this space. So just having that open dialogue can be so important. All right, so I have about 9 slides here that I'm actually going to very quickly jump through out of respect for time. But I'd like to thank the North Carolina Department of Health and Human Services for providing these. It really goes through 9 of the more unique spaces that say, oh, well, we can't support XYZ because we're this type of business and we don't allow. So this gets really creative, quickly highlighting some pieces off of each of them, and you'll have these slides in the follow-up. So retail spaces, a dressing room converted into lactation space. Great idea. Also, this goes for retail stores and small businesses, but coming together with other small businesses in your area to create a centralized shared space as well is a great opportunity. Restaurants, obviously, manager's office is an opportunity. They even have in here a partition or private screen in the corner of the kitchen area. That's one, if you ask me as a nursing parent, I might not be as comfortable with. However, it does meet regulations. But once again, we want to go beyond just being compliant and making sure that we are offering an attractive work environment to, try to retain talent as well. Okay, gonna keep jumping through here. I love the pop-up tent that 𝗪𝗟 mentioned as well. I know that was one, as I've talked to construction companies before, where I'm like, oh, you guys would be the exception, right? But then understand that there are really creative and wonderful ways to support that nursing parent. Pop-up tents, managers' offices, or portable buildings as well, bringing those in. Once again, just being thoughtful of those essential pieces as well to make sure they're actually functionable and able to be leveraged by that parent. Manufacturing plants, I think the additional one that they had here was constructing a space using cubicle partitions or metal shelving and plywood. So getting a little bit more creative and building a space for those parents. Healthcare agencies, maybe a private exam room that's not being utilized. Hotels, once again, an empty guest room, so another space that isn't being utilized. Emergency personnel, back of an ambulance. And some other options like this. So once again, kind of thinking outside the box and how you can meet those employees where they are to support them in this space. So quickly jump through those. I definitely encourage you to take a look if one of them aligns with your workspace. So you can get creative, or once again, we can have a conversation, put our heads together and figure out a different alternative as well to support that parent. So when it comes to milk storage, there are a few different options. First being a public shared refrigerator. I'd like to specify that breast milk is not a biohazard. It's considered a food byproduct. So it can go into any regular refrigerator. We just want to ensure proper labeling and hygiene practices, and furthermore, make sure nursing parents are comfortable with having a public shared space. Option 2 is a personal cooler. That's something that the employee can provide on their own, or maybe that's an opportunity for a branded cooler provided by the employer as well, as a kind of a sense of support within that space. Last being a company provided mini refrigerator. This could be something that you have in nursing parents' office, or maybe it's something that you actually keep in the shared lactation space. All opportunities, but regardless, once again, talk to nursing parents, see what they're most comfortable with to make sure they have what they need. Okay, diving into a flexible break in time. This one's very important. I know if you were to ask me when I came back from my maternity leave, how many breaks do I need or how long do I need? I wouldn't be able to answer that because I didn't start pumping until I came back to work. So that would be a space that I was definitely not as educated on. But now I think it's really important to recognize that different women may need varying amounts of break time to pump. The frequency and length of these breaks can depend on factors like milk supply, baby's feeding schedule, and additionally what kind of pump that they're using as well. So on average, mothers need about 2 to 3 breaks during an 8-hour workday, with each session being 15 to 20 minutes, sometimes longer as well. Employers should avoid assuming that all employees need the same amount of time. So I would say, gosh, so-and-so is taking 3 breaks and they're all 30 minutes when the other individual is only taking 2 at 15. This is very unique to nursing parent. But what we want to do as employers is support them in that journey, check in with them, make sure they have what they need to be successful in this space. Okay, from a scheduling standpoint, once again, a lot of different options here. One option is using a dry erase board on the exterior of the lactation room, where employees can simply just sign up for time slots. Another option might be a shared calendar managed by HR, which helps maintain privacy while keeping track of room usage. Additionally, options could include first come first serve system with an occupied sign outside of the door. If that's something of interest to you, I would definitely connect with the milk bank and request one of their lactation room support kits. There is a very well put together branded occupied sign that you guys can utilize. That's going to be most successful for employers that have fewer employees that are utilizing the room. It's also important to survey your employees and see what they're most comfortable with from a scheduling option as well to make sure their needs are met. Okay, educating employees about breastfeeding lactation support is vital. So providing this prenatal education, offering postpartum lactation consultations, connecting employees to lactation experts, the community, all of these pieces. This is an opportunity for you as an employer to do a little of your own research, connect to local hospital systems, talk to your insurance provider, see what exists for the employees that you serve that are under your healthcare plan, and put that together for them. And we'll talk a little bit about kind of an onboarding process and program as well here in a couple slides. But this is a great show of support. Mothers have a lot on their plate. They're thinking about their nursery, they're thinking about preparing for maternity leave. So this is an area that you can support them in their health and wellness. Okay, so diving into support. So creating a lactation-friendly workplace goes beyond just having a lactation room. It's really and truly about embedding lactation support into your workplace culture. This includes training your managers and supervisors, having a formal lactation policy, and ensuring you have ongoing communication with mothers returning from maternity leave as well. So within that formal policy, this is a fantastic place to start, and we will be providing a sample policy for you guys to utilize as well. But the importance of this formal policy, it really supports those breastfeeding employees by outlining clear expectations and rights, including the process for requesting accommodations. It defines both the roles of the supervisors and the employees, helping avoid discomfort when discussing breastfeeding needs. The policy ensures managers know how to support employees returning from maternity leave, and also clarity on the support available before they return back to work. This really keeps everybody on the same page. As we think about those supervisors and managers, the fear that, gosh, my HR really gets it, but I don't know if my managers on the same page. I really feel like I'm putting everybody out. What does that look like? So that's comfort for the parent that's returning from maternity leave, as well as for that supervisor and manager to understand what their role and what they're accountable for as well. So I had the sample policy here, a little over time, so I'm going to keep jumping through here. This is one of my favorite pieces, is the maternal onboarding program. So when mothers turn to work, a comprehensive onboarding program is just essential. So it's a discussion of lactation policy, that once again, that reassurance from their supervisor, and a review of the work schedule for expressing milk needs. Feedback from those employees is just, supervisors is crucial. And I actually recommend this piece being before mom leaves for maternity leave. I know someone that in my situation who was very apprehensive. I was very worried about my return to work before I even left. For someone, my HR person, to walk around with me and explain to me what the onboarding process would look like, explain to me if I'm choosing to pump, this is what the space would look like, this is how I'd leverage that. These are all the benefits provided to me as well. Before my brain is too foggy with everything, that just really made me feel supported by my workspace. So I felt that support the entire time I was gone, as well as having access to all those great resources as well. while I'm gone on maternity leave and able to utilize those for the weeks I'm gone. Couple more slides here. Maternal mental health is an often overlooked aspect of employee wellness. Employers should ensure that mental health resources are accessible, and that there is a return to work plan in place. Really thinking through those regular check-ins with that employee, making sure that they have access to a list of resources they can utilize, making sure they understand how to leverage their EAP if you have an EAP with your workspace. And I do want to note here that mothers can experience maternal mental health disorders up to 1 year post-birth. So that it might not have an onset until 9 months, 10 months after the birth of their child as well. So that's why that ongoing check-in communication from that manager supervisor is just vital in making sure that parent is taken care of. Okay. And I would say this is a much larger conversation and probably for an entirely additional webinar. However, I still wish to include that in today's diverse workplaces, it's essential to offer family forming benefits that are inclusive of all family structures, whether employees are part of the LGBT families, single parents, or other varied setups. Equitable access to benefits like adoption support, fertility treatments, and surrogacy are crucial. By embracing these diverse needs, we demonstrate a commitment to inclusivity and ensure that all employees feel valued and supported in their family building journey. So that's another piece we'll talk about in our consultations as well. I have the link here to sign up, and I know the Milk Bank has quite a bit left to go over the last 4 minutes, so I'm going to stop talking. Just thank everybody for being here today.
That's great, Ashley. And Ashley and Shelley, we knew that you would just be delightful, but I really love how approachable your take on compliance and how we can really create win-win situations for our employees, employers, and our families. So I do want to thank everyone for attending. I know we have some couple burning questions in the chat that I want to give some time for, but just know that you'll be receiving a follow-up brief survey to kind of let us know really, what some of your ahas were around this. Also, the recording and the slides will be available for you. And we're also going to post that on our website. So if you know of other folks that might benefit from this content, it's going to be accessible for everyone. Also in that survey is where you can request those lactation room support kits. And there's just really great supplies for pumping moms. Also a great diverse children's book around pumping at work and lactation in general. And that's going to be available to you all as attendees, but also folks you refer back to the website. So we'll get all of that out to you. And as I let Ashley and Shelley grab some water and take a breath before getting to the questions, I also want to really celebrate everyone in this room, the friends that come alongside of us every day, and also the new faces to say hello to. And I want to really invite you to think about what it means to be a public health champion in this space and how we can really address infant mortality and support women in the workforce. We know at the Milk Bank, not everyone has this superpower to donate milk, but we firmly believe everyone has the ability to save an infant life. And we are absolutely committed to uniting our communities to urgently reducing the alarming infant mortality rates that we see. We are, as a nonprofit organization, completely reliant on the generous donations that we receive to meet the needs of more than 70 hospitals across the Midwest and beyond. We are often called upon in crisis situations to step in and support communities actually around the country while prioritizing those in Indiana, Kentucky, Missouri, and here in the Midwest. With every $5 donation you make, you can offset the cost for 3 feedings for the most medically vulnerable infants. And if this work today really speaks to you, consider making a donation that allows us to create a space for bereaved mothers to participate in a support group, or even sponsoring one of the lactation room kits that we're giving out free to employers across the Midwest. So just like every ounce counts, every donation counts for us as well. Also, remember, you are now part of the Milk Bank family. You're stuck with us. And so please stay connected with us on social media and tag us if you're talking about today's webinar, aha that you learned, or at least follow us to learn about the impact that we're making together in partnership with you. So Amy, I know we had a couple of questions. Can you tee us up to make sure those get to Ashley and Shelley?
Yeah, absolutely. If we can't get them all answered, which I don't think we will in our time, we will also post them on that employer site, the Milk Bank's employer site that we've been posting in the chat. So do we want to try to answer a question here in the time that we've got? Let me just pick up the first one that came up. Give me 1 minute here to take a look to find it. It was related to, Shelley, you had said there was temporary limitations on ability to perform essential job functions. Can you share an example? For example, does that mean adjusted productivity goals due to time pumping or the ability to travel for business?
It can really depend on the nature of the job. An example that I would say from my discussion that we talked about is lying on your stomach. If you have a job where you lie on your stomach, you may not be able to lie on your stomach for a period of time, entirely unable to do it. That doesn't mean it would depend on the job as to whether that is you just have to perform the job in a different position, or whether you can't perform the job in a different position and would then be considered unable to perform that particular job during that time frame. But yeah, it could be any of those examples that you listed would be an example of a temporary inability to perform or a need for accommodation essentially during a time of pregnancy. So it's a wide range.
Great. So I know we're right at 1 o'clock, but this next one, it feels a little unique. So if you have to drop off, feel free to go ahead. Of course, we have to respect your calendar. But if Shelley and Ashley, you're able to answer this one was regarding a wearable pump in the workplace. So all the details in the chat, but essentially it boils down to, has there been any discussion around a wearable pump? And is that if an employee is doing a wearable pump, is that considered being relieved of their duties, or can they continue to pump while they're being paid? Just wondered if those questions, if you're familiar with those questions.
You know, I have not had that question come through in working with an employer. I guess I'll defer. Ashley, have you? And because I have some thoughts, but mine is more hypothetical than actual.
I would say I have not had that come up from, and honestly, it's kind of a more policy-based question as well. So I'd lean on Shelley for that. And if Shelley's got a clear answer, I'd also just once again talk to your HR compliance team and see if there's any policies currently in place.
So I hear a couple of things happening here. The first one is creating creative spaces for individuals to be able to pump milk. That sounds great in theory. I think the challenge here is what I'm hearing is there is a staffing and logistics problem in that kind of a scenario, which is there's not enough staff to take a break that is sufficient to allow the employee to engage in the pumping activity. There isn't, you know what I mean? To me, it feels like it may be a situation where there's no prohibition that I would be aware of on the wearing of a wearable pump within the workspace, assuming there's not a safety issue or some other, like you're not in a sterile operating room that can't have outside devices, things like that. I mean, I'm not aware of any problem that would create, but to me, it becomes more of an issue of exploring what's happening there. Is there a way to allow that employee, because as I understand the scenario, an employee is saying, I need to pump, but I can't get the break time to do it. Now, there is a provision in the Pump Act that says if a non-exempt employee, that means an employee that is paid minimum wage and overtime, typically hourly, but there are some other arrangements as well, they can actually essentially be paid during their pumping breaks, right? If they're not doing any work at all, they don't have to be paid. So you have to kind of think about that. So you can have a pumping break where people are being paid, but that would not meet the requirements that are established in the private location and all of that. So I have to say it from a compliance standpoint, I would have some pretty serious concerns if the message to employees was, put a wearable pump on and keep performing your work duties. That's not to say you should shut it down if there's some way to maintain basic compliance and also offer that option as an enhanced option. For example, if someone wants to pump more frequently than would be warranted, and there's some reason to do that, I suppose. The other thing I want to say very quickly is keep in mind that the Pump Act, which is the second one that we talked about, that is essentially creates lactation support, is also bolstered by the Pregnant Worker Fairness Act. And so pregnancy and breastfeeding is actually considered a condition related to pregnancy under the Pregnant Workers Fairness Act. And so I think there could be some accommodation needs there to adjust a work schedule to allow an employee to pump and not force an employee to work within the workplace with a wearable pump, unless that wearable pump and that arrangement is a reasonable accommodation. So the answer is, I think it's a complicated question. I don't think there are easy answers, but Ashley was like a shining star of the idea of the interactive process. When you heard her talking about working with employees, communicating, it goes so far. So that would be, that's kind of my rambling response to that particular compliance issue.
Well, that was great. We have a couple of others, but I just think out of respect of time, I will follow up with those questions with both Ashley and Shelley, and we'll put those questions on as like a FAQ on our employer site, and we'll make sure that everyone in attendance has access to that site when we follow up.
Wonderful, everyone. Thanks for attending. Please watch for that follow-up email and join me in celebrating our expert speakers, Ashley and Shelley, for donating their time and their expertise today to really build family-friendly workplaces that we can all successfully pump and navigate.